Welcome back to Employment Law. This is our first substantive lecture. You'll recall that the last lecture was just an introductory one, and I took you through Moodle just a bit. We discussed the assessment, what they look like, and that's also available on Moodle. And you would have hopefully gone on to the introductory section already and watched that video. If you haven't, please follow this link here. If there were particular, the PowerPoint slides are embedded in the video, but if there are particular slides or information that you wanted, then the slides are available separately so that you can print them out. So for today's purposes, we're looking at employment status. The slides are available here and the link will be available shortly. Now, if you recall from the last our introductory session, we looked at what employment law covers. And a very basic definition is that it covers all the relationship issues that arise between an employee and an employer. Okay, simple enough. But employment law can also be concerned with other people who are engaged by employers to carry out services, but who may only be employees in certain circumstances, for certain purposes, for example, or who are actually workers rather than employees. And this is an important distinction, the distinction between whether a person is an employee or whether they're a worker, because they have different rights. So today's lecture is about just that, what is called employment status. And that means from a worker or the laborer's perspective, if they're looking at it, what is their status if they're working for someone? Are they an employee or are they a worker? And they would want their status defined very clearly because it depends what kind of rights they're entitled to. Now, this area seems to be the area where law students get the most confused and tangled up about. It's not the most straightforward, but equally I don't want you to get too bogged down by these concepts or to put off by employment law that we've taken the most difficult topic first. So in terms of the legal framework, it's important for you to understand that there are 3 tiers of employment as set out there: self-employed, worker, and employee. Each of them have different rights, particularly in respect to statutory sick pay, holiday pay, pension contributions, the right to unionize, etc. So it's very important for a person, if they're trying to assert particular rights, to know where they fall within these tiers of employment. And you'll see it's written in red that there's a statutory definition for both worker and employee, but there is no statutory definition for self-employed. And if we pause here for a moment, if you think back about people who are working have been in the news where the status of that Deliveroo driver, for example, is unclear. Are they an employee of the company of Deliveroo or are they self-employed? So that's what we're talking about today. So it's a bit of a convoluted statutory definition, but there's the old-fashioned concept of master and servant, and those people who perform work for others are not always employees. It depends on whether or not they're under a contract of service or whether they're independent contractors and work under a contract for services. And it's that tiny difference that's set out in red that makes all the difference when determining the individual's status. So every employee is a worker, but not every worker is necessarily an employee. Now, I'll explain in a moment. It's like a tier system. If a person is self-employed, they're completely outside of the regime, and I'll explain that in a moment. Workers have basic rights. They have the right to a national minimum wage. They get paid holidays, paid rest, and they also have certain protections under the Equality Act. So that's a worker. Employees, which is here in the middle, they get everything that a worker gets plus more. So it's worker and then employee, if you're looking at it in a pyramid kind of format. So employees get all of this plus extra things, which is statutory sick pay, maternity, paternity leave, pension contributions, the right not to be unfairly dismissed, provided they've worked for that employer for a period of 2 years, and they have a right to join a union. And employed people, because they, self-employed people, because they manage themselves entirely, take on all of the financial and business risks, have perhaps you would quite rightly, or in a common sense way, don't have any of these statutory rights, because what they enjoy in flexibility and what benefits they derive from that, as a result, they give up their right to certain protections that workers and employees have. So first, without getting too bogged down in definitions, just to start to understand that there are these three different categories. Now, again, to emphasize, aside from some of the rights that are different between workers and employees in terms of what they can enjoy, there are other differences which make the distinction between the two quite important. And that's that self-employed people are taxed completely differently under Schedule D, which we don't need to go into a lot of detail about. Employers are vicariously liable for their employees, and I'll explain that in further detail later. And employers owe a duty of care to their employees. Now, workers and those who are in the gig economy, those self-employed people who, so your Uber drivers, Deliveroo, maybe Amazon parcel delivery people, plumbers in certain circumstances, they work in the gig economy, and there are about 5 million people in that economy. So casual, flexible jobs, they are generally part-time, they're not unionized, they're quite insecure jobs in the sense that they don't have any real job security, and they also generally tend to have more women working in those areas. So maybe things like care for elderly people, and in creches, childcare, etc. And then you have the specialized or skilled jobs where they're a lot more secure, permanent. They tend to be more men, and so this is just the dual labor market hypothesis that just basically has divided people into these two groups, and they've found that once a person gets into one segment of the market or the other, they tend to stay there for a large part of their working life. And if the security is so much less in the gig economy or for casual workers, or their rights are much less, and it's difficult for them to move up, then it's something as an employment lawyer that you have to recognize and understand as a potential issue. So going back, we need to look at the statutory test, and you need to be familiar with the legislation. So let's start with that. It's the Employment Rights Act 1996 that determines whether or not a person is a worker or an employee. And that's your starting point. There's case law that has been developed as well, but we'll move on to that in a second. Let's look at the statutory test. The first thing is that an employee is defined in subsection 1 as a person working under a contract of employment. Okay, fine, simple enough. A worker there's a 2-limb definition for it. They have to be working under a contract of employment. Okay, fine. It has to be any kind of contract. It can be oral or in writing, etc. They have to agree to personally do the work. So it's them who undertakes the tasks. It's that person who will deliver the meals if they're a deliverer. It's that person who will deliver the parcels if they're working for a courier company. So they personally provide the service. They can't outsource that to somebody else to do it. And they provide the service as part of someone else's business. Again, that makes sense. So a Deliveroo person carries out that task or that service of delivering the food as part of Deliveroo's business. It's not their own personal business, right? You do need to be familiar with the legislation. So it's section 230, subsection 1 for employee, and it's subsection 3 for worker. And you have to understand these two limbs of the test. All right, that they must perform it personally, and that they do that as part of someone else's business, not their own. The case law has been developed around the interpretation of this statutory test. Okay, so when we're looking at worker, this is the checklist that you'll go through in your mind. Is there some kind of contract? It doesn't necessarily have to be written. It can be orally agreed to. Does the person personally carry out the work? So can they send in their friend or somebody else to do it for them, or is it necessary for them to carry it out themselves? And then are they providing the service as part of someone else's business or not? Okay, so that you understand the difference between employee and worker. Now let's move on to the third tier. You remember the cake. The third tier is self-employment. Now, I just want you to pause for a moment, maybe pause this video and write down on a piece of paper, just jot down what characteristics you would attribute to genuine self-employment. So when we look at genuine self-employment, you might think of a chartered accountant, who runs her own business, or an architect, or maybe somebody who owns a shop. So if we look at it in a very general and common sense kind of manner, you would understand that the person has complete freedom to enter into contracts with other people or other businesses. Somebody who's a chartered accountant might do business with several companies all at the same time. They'll fix their own price for the services that they're rendering. They are completely free to set their own time scales as to how and when they will finish the work. They're not supervised. A chartered accountant or somebody running an interior design company or an architect or shopkeeper might hire their own employees to help them and delegate work to them. They take on all of the financial risk, and as a result, they have all of the gain, all of the profit, and they generally own their own premises from where they work. All right, so what self-employed people gain in freedom and flexibility, they lose in terms of certain rights or statutory protections, like we saw holiday pay or sick pay or pension. That seems reasonable enough, and provided these people really are self-employed, it seems quite fair and quite reasonable. But the difficulty is that as the casual economy has grown, the gig economy, and we have the likes of Amazon, Deliveroo, and others, there's a very blurred line between those who are in genuine self-employment and those who are workers. And that's what we will look at in further detail now. So it's that blur between the two that makes it often difficult to distinguish between who's an employee and who's a worker. And there's some case law on it, quite old, but is worth having a look at. It will certainly be in your textbook. Now, in addition to the statutory test, section 232 and subsection 3 that we looked at, that defines an employee and defines a worker, besides that statutory definition, that's our first port of call. You always look at the legislation first. But in addition to that, there's been a common law test, so case law that has evolved, looking at the statute, and it's the common law test also have a lot to say about determining whether a person is a worker or an employee. So we need to look at the common law test. The first you'll see are in red there. So it's about how much control the employer exerts over the employee. So how much control do they have over them about what work they do, how they do it, in what time frame they do it, how they're paid, etc. Whether the person personally renders that service, or whether they can delegate it to someone else to do, and whether there are obligations on both sides of the relationship, so mutual obligations. And the leading case is Ready Mixed Concrete and Minister for Pensions. It goes all the way back to 1968. But in that case, the judge said that the irreducible minimum for a person to be a worker rather than self-employed is that these three things exist. That's the leading case law, the leading case for this. But it's moved on a lot as the world has changed from 68. Technology has changed and developed. So has the case law. So courts will also look at the economic reality of the situation. So how dependent the person is on their employer, economically speaking, and how integrated that person is into the employer's business or company. So they'll look at those factors also. A more recent case, which is Autocleanse and Belcher, 2011, said that we don't care what's written in the contract. The judges said we don't care what's written on paper. What we care about is the reality of what the person actually does, the reality of the work that they carry out, and the relative bargaining power between both parties. So we're going to look at not what's written on the document to determine the status of the person, but we're going to look at the reality of the situation and delve into what their day-to-day responsibilities are. So in this way, the courts have formulated a variety of tests to identify whether or not there's a contract of service, because if you go back to the definition, section 230, it's a contract of service. And those tests in the key case law are the control test, the integration test, economic reality test, and the most recent one now is and the most relevant for the working systems nowadays is the multiple factor test. And that was approved in the AutoCleanse case. So again, I would advise you to go through your textbooks to read about and understand these tests in a little bit more detail. Just again, to go back to AutoCleanse, what the court said in that case is that it's going to be a mixture of law and fact, fact meaning the ground reality, what work the person is actually carrying out, that will determine the outcome in the cases, the outcome being the determination of whether the person is an employee or a worker, and that it's not necessarily what's written on paper. So that they probably came up with that so that clever lawyers can't circumvent the law by drafting documents that are very clever, defining people as workers when the reality of the situation might be different. Or what's more common is clever lawyers defining them as self-employed people when they might be and have been held to be, in other cases, workers. So there have been a lot of recent cases on the gig economy, and you'll see some of the names there. Uber, City Sprint, and many, many others. What I'd really appreciate that you do is to look up some information on some of these cases. You can go into newspapers, reputable newspapers like the Times or the Guardian, to read about these, and I want to discuss them. And to be more precise, I'd like you to discuss them, please, in the workshop that we have about what did you find out about these cases, in which cases were the people held to be workers and why, and in which cases were they held to be genuinely self-employed. So that's what we want to look at in the workshop. And so please be prepared. Now, to get you prepared for the workshop activities, and also just to reinforce what I've been talking about and to apply that in practical terms so that you really understand, we're going to play this game sort of thing where you decide whether, based on the facts that are in front of you, whether the person is a worker or they're self-employed. Now, bear in mind the definition in Section 230 of the Employment Rights Act, and also bear in mind the control, the various common law tests, so control, integration, etc., those tests. So if you are given these facts that there were certain riders, on bicycles or whatever, who were under what was called a supplier's agreement with the person who's called a principal rather than an employer, to deliver food to customers via that principal. So they call it a principal rather than the employer for obvious reasons, so that they can circumvent their obligations under the Employment Rights Act if they were to be called the employer. So from the principal's perspective, they are trying to make this look like a self-employment relationship. In any event, so that was just to explain why it's called a supplier's agreement and why the other party is called a principal rather than the employer. But these riders deliver food to customers via the principal's app. The riders log in and out of the app whenever they want. But once they're logged in, they're tracked by using the principal's GPS and they have to go to the closest restaurant, but they have 3 minutes in which to decide whether or not they want to decline to take that delivery or not. So they have a certain amount of time. Based on those facts, and these alone, is all you have in front of you, looking at the common law test, looking at the statutory definition, do you think that the rider is a worker or self-employed? Okay, so you've thought about that for a moment. What if there's a new contract that is introduced for all of the riders, and the new contract says that the riders are allowed to appoint somebody else to carry out the work for them, and that some of these riders will ask their friends, so John will ask Ahmed that, hey, you want to take this delivery for me, and I'll take a cut of the payment that you're getting. So they're delegating the work on to somebody else, or they're subcontracting, to be more precise. And due to that subcontracting, they're getting a cut of the money. Now, would you still say that the person, if you decided on the last slide that the person was a worker, do these facts change your mind? Do you think that, well, if they can substitute someone else, then they are probably self-employed? And again, if you've maintained the same decision, why have you maintained the same decision? And if you've changed your mind, again, why have you changed your mind? If you could think about that. Going back to remember the statutory definition for worker. It's about personal service. They must personally render that service. Now, if they do that, then they're a worker. Now, the substitution clause in the new contract saying that they can have somebody else do the work for them, does that take them out of the statutory definition? Does that take them out of that and now make them self-employed? Probably that is probably the case. Now, let's add other facts into the mix. Let's look at it from the rider's perspective, a rider who is arguing that they're not self-employed despite the substitution clause. So they're not personally doing it anymore. They're allowed to substitute someone. So they're outside of the realm of worker, but they are arguing that they want to be a worker rather than self-employed. So what if they put forward arguments that, look, the principal spends a heck of a lot of time and money and resources, energy training us, and it just simply doesn't make sense for them to spend so much energy and money and time to train us if then we can turn around and substitute somebody else to do the work for us. So it just doesn't, going back to auto cleanse, looking at the ground reality of things, not what's written on paper. And another limb of that argument might be that there might be a regulatory risk, regulatory in the sense of health and safety and food hygiene legislation about substitution, because if Ahmed, who doesn't have the same training as the first person, is delivering food, and he hasn't had that training on food hygiene and other things, then potentially there's a risk, and therefore it's not really, although that clause is written on paper, it's not something that is simply not realistic. Another argument that could be advanced by the riders, lawyers, are that, okay, fine, there's a substitution clause in the contract, but actually the reality of the situation is that it's only once they've accepted the job that they can, and they have that 3 minutes in which to accept a job, that the actual possibility of finding a substitute arises. And therefore, even though hypothetically it's possible to find a substitute, in reality it's not really just possible. And therefore, it doesn't have any real effect, this clause in the contract. If you heard arguments like that and were listening to facts of a case like this, again, would it change your opinion about whether the person is a worker or genuinely self-employed? I'm going to give you the outcome of the case. All of the facts that I was just discussing are were just looked at in the Deliveroo case. Now, this was decided by a Central Arbitration Committee and not a court, which is a bit important from a lawyer's perspective. But the decision was that they were not workers, that they were, in fact, self-employed people. There was a different outcome in Dewhurst versus City Sprint, which was at the Employment Tribunal, where those riders, again, doing something very similar on cycles, delivering things for City Sprint, the claimant Dewhurst was held to be a worker because of the working conditions that she was in meant that she was integrated into City Sprint's business. And why is integration important? Because that's one of the tests, one of the common law tests, if you remember, about how integrated a person is into the other's business. So two different outcomes for facts that were quite similar. So if you were discussing this with your other classmates or colleagues and you had different opinions on it, that's not surprising. The judges in these cases often can't decide on the status of the person. When it goes to the Supreme Court and there's a larger panel, you sometimes have a dissenting opinion. So if they can't decide at Supreme Court level, the judges amongst themselves, then you should understand that there is no wrong or right answer. It is a difficult area, and it's fact sensitive, and it doesn't make it easier that there isn't any statutory definition for self-employment. Let's move on to a next set of facts. So here, in this case, there's a plumber who is, labeled as being freelance, except they have to wear a uniform, wear a company badge, hire a van that has from the company, and it has the company's logo on it. They must work 40 hours a week, and they're restricted from working for competitors after they leave the job, which I touched on. That's called a restrictive covenant. So once they stop working for that principal or employer, they can't work for a competitor for a certain amount of time. And but however, they are allowed to send a substitute in to do the work for them, but only somebody who's already working at that company. So it's a plumbing company, but so they can send one of their colleagues from within the company, but not a friend. Do you think in these circumstances, and look back at the control test, integration test, multi-factor test, etc., the common law test, and the statutory definition, whether with these facts the person would be a worker or self-employed? What do you think? What happened in this is that the court decided, and it was the Supreme Court back in 2018, decided that Mr. Smith was in fact a worker. And they found this on two points, really. The first being with regard to substitution. So Mr. Smith didn't have the right to send just anybody in to do his work for him. He had to find someone from within the company. And also on so that is the statutory thing about personal service, and how genuine the substitution clause was, and also finding that Pimlico, the company, was not Mr. Smith's client or customer. So if you remember going back to the statutory definition, 230 subsection 3, about the business that they're doing, whether they're part of somebody else's business or they're running their own. So Mr. Smith, if he was genuinely self-employed, he would be the client or customer of Pimlico. So this was a pretty important case, at least for Mr. Smith and his colleagues. However, these kind of cases are very, very fact sensitive, and therefore probably don't set much of a precedent. So even though it was in the Supreme Court, it's unlikely to really set a precedent on the lower courts in terms of defining employment status, because they're so different in terms of facts. Let's look at other factual findings which led to a decision that the claimants were in fact workers. And this is the Uber case. And I hope you've read about this in the papers, or you've seen this in the news. Basically, the facts were that Uber would set the fare, and the driver couldn't agree any higher sums or lesser sums with the passenger. So that really flies in the face of self-employment, where people who are genuinely self-employed will determine their own remuneration. They determine or negotiate how much they're going to charge. So the Uber drivers don't decide this or negotiate this with the passengers. It's fixed by Uber. The route that's taken to drop the passengers off are decided by Uber. And they have, the drivers have 10 seconds within which to either accept a fare or not. And if they decline 3 consecutive requests, they are automatically logged off. And when they're logged off the system, even if it's for a short while, they're not making any money at all. And that shows a couple of things. It shows that it's a penalty, and it's something that's used to dissuade the drivers from not accepting fares, and also that Uber is exerting quite a lot of control over the drivers. And they also were subject to a performance rating system, like performance management. Again, do those people who are genuinely self-employed, do they manage themselves? They're not subject to performance management or any kind of controls. They work their own hours. They decide how they carry out the work for themselves. They don't have default routes that are set. So it really is showing that that this idea of flexibility, is it one-sided? Is the flexibility only for these large companies like Pimlico Plumbers and City Sprint or Deliveroo, Uber, or are these people workers or self-employed? Are they being exploited? So I would ask you to look at some of these cases where different decisions were held in them. So in Addison Lee and City Sprint, they were called workers, but in Deliveroo, they were not. They were not workers. That was in an arbitration committee. That's important to remember. And the issue that was being decided was whether they could unionize. So I just want you to think about those. The legislation is extremely complicated. As Lady Hale herself said in the Pimlico case, where she said it's regrettable that in this branch of law, the same words can have different meanings in different contexts, but it gets worse because different words can have the same meaning sometimes. And that was in paragraph 7 of her judgment, but it really does highlight how convoluted really the area has become. But it's really important for those people who want to exert rights and want to move up from being self-employed or being wrongly labeled self-employed to being workers because they want statutory sick pay or they want holiday pay. It's important to get the definition right. There are, and I'll leave these for you to read, there are different recommendations about how the law can be changed. So codification of the case law, for example, that looks at the different tests, increased awareness amongst agency workers about their rights to paid annual leave, etc. This was a huge area that was looked at under So under Theresa May's government, there was the Taylor Review, which looked at the whole gig economy and whether people are being exploited and what can be done to change the situation. And that's largely because the government is losing out on taxes because self-employed people pay their own taxes rather than and national insurance contributions rather than the employers paying them. So there are suggestions, as I said, about making a statutory definition of self-employment. That's one idea. Moving certain employee rights to workers, so to be a lot more generous, and it would protect some of the most vulnerable workers. And if you look at the kind of profits that places like Sports Direct or Amazon are making with regard to 0-hour contracts and agency workers, it might seem to some people that would be more than fair that they pay, that these huge companies do pay national insurance or pensions to people delivering our parcels or working at Sports Direct. And that the tax regimes could be aligned, which would certainly bring in a lot more revenue. Just by way of information, and it's quite interesting. I thought that all of this started out in Silicon Valley because of technology and the way technology has changed, where employers can exert control from far by using GPS and various apps. So they can still control them, but in a different way. So this all started out in California, and it's there that they've changed the law to bring in where the default position is that a person will always be a worker or an employee. The law is a little bit different in terms of the definitions, but they will always, the default position is that they are an employee and that they're entitled to certain things. And it's only if that can be disproved that then they're self-employed, which is, and that has saved and brought in a massive amount of revenue for that state in terms of taxes. So that's a whirlwind tour of employment status. It is, and I do appreciate the fact that it is a complicated area, because of the statutory definitions particularly, but take time and go through it, and we will consolidate some of these ideas more in the workshop. Please come in prepared to discuss these cases and your views, please. And the link to this recording will be here under employment status. Please look at some of the seminar questions ahead of the workshop on Tuesday. Thank you very much. See you soon. Bye-bye.